Greetings to everyone watching. My name is Amanda Shabango and I'm with
Nompumelelo Qiliza, and
Welcome to our podcast.
In today's podcast, we'll be tackling the question of whether natural law approaches can still be justified in today's modern legal systems. And honestly, I think natural law approaches can still be justified.
I would like to disagree.
Okay. Well, since we now know what stance Amanda is taking and what stance I am taking, let's find out what the nature of law is, what legal positivism is, and what natural law is, and get into it. The nature of law is defined differently by separate theories of law, namely the theory of legal positivism and the theory of natural law.
Legal positivism is based on social facts, including of how people think and behave. So theorists such as Austin, they encourage the use of the separation thesis to try and draw a distinction between law and morality.
On the other hand, the theory of the nature of law is basically a combination of justice and morality being built into the idea of law, where laws that are unjust or lack morality are considered like moral legitimacy or legitimacy. Now, why do I say that natural law approaches can still be justified in modern legal systems? I say this because law is not merely a system of rules, but it's also a normative institution that claims authority and seeks to guide human conduct through reason. Natural law then provides a more complete account of this by recognizing that law must engage with rationality and moral purpose, rather than existing as a purely mechanical set of commands. What do you think? What do you say?
As I've said already, that I would like to argue on natural law systems being still being applicable today. I say this because of many reasons, so I'll get into one now. So the first reason why I don't believe as such is that natural law may create a lack of argument. So I say this because law may create a lack of agreement on moral views, because it is based on the idea that law comes from universal moral principles, which is a problem in modern society because people are pluralistic in many ways in terms of religion and cultures, and what one person believes to be morally correct, it may be different to the other person. The reason would be that natural law often creates subjectivity and uncertainty. Why? Because different judges may interpret the law in different ways, in ways of such, because there's no set of written rules or anything that can help, or the doctrine of the stare decisis, which can help the judges to regulate or what the decision.
Amanda, you did mention something around universal morality, universal principles, yes, basically. So I have to say that while natural law in the past, in its classical sense, and not in today's world, it was strongly associated with morality, and it was often grounded in divine and universal principles, as you have mentioned, where thinkers such as Aquinas viewed law as being inherently tied to a higher moral order, leading to the famous idea that an unjust law is not a true law. For example, you think of a law like apartheid. You'd say, according to natural law theorists, they would say apartheid was not a true law because it wasn't just, right? However, because of the problems this rigid approach of universal principles, as you have mentioned, it caused so many problems in the modern legal systems. It posed difficulties because it failed to account for the reality that laws can be valid and enforceable even when they are seen as being unjust or when they are unjust. So the classical view has therefore struggled to accommodate the complexity and institutional structure of contemporary legal systems.
So I'd also like to argue on the argument of natural law or an unjust law in natural law is not a law. So it is important to note that immorally systems can never be recognized as law that regulate acceptable behavior in society. However, it is important to note that there's no objective morality or morally meaning. So another reason why I argue behind legal positivism is because natural law acts as a reason not to punish. Why do I say this? It's because in a legal setting or in a court setting, when a judge has to convict someone who's maybe committed a crime, it is morally acceptable that the person should not be convicted, because why would you convict some duty that the judge should not convict the person, which according to law or written laws, that wouldn't be acceptable.
Okay, I hear Amanda's point, but honestly, that's not what natural law is, especially in modern legal systems. Why do I say this? Natural law has evolved from the rigid approach that it used to have, of which I believe your argument also relates to natural law in the past. It has evolved. It has become more flexible in a sense that it now coexists with legal positivism. So it now complements modern legal systems by recognizing legal validity, while also still insisting that morality plays a crucial role in understanding and applying the law, and not just insisting that unjust laws are automatically invalid, right? So the focus has shifted from morality alone. It also now includes rationality, arguing that law must function as a rational standard for conduct. Modern natural law, therefore, aligns more closely with constitutional democracies, where principles such as fairness, justice, and reasonableness play a central role in interpreting and applying the law.
Okay, you talked about flexibility, and I would really like to know how these natural law legal systems are being applied when they're not written down, they're not statutes. Like, how do you guys apply the natural law in like modern society, like in societies of people? Because Umbiti also speaks about kinship, which kinship states that kinship, which John Pittsey discusses kinship as an important system in which natural law states how a person in a community cannot be independent without family or relatives. I may be wrong, but that's how I understood kinship. So I feel as if that concept, it does not cater for the people today, because it doesn't make sense for someone or for a legal system to state that a person cannot be, dependent, without his society or the people around the society. I think I'm not understanding. Maybe we can explain more so that I can get the understanding.
So regarding your first point, regarding how natural law is actually applied in the now, because it's not written down, of which you are not wrong, it is not written down, but it is applied based on morality. I don't think morality has to be written down for it to be applicable in law or anything as such. So I'm going to use a case as an example. The name of the case is Minister of Home Affairs versus Fury, where the relevance of natural law in constitutional democracies is demonstrated in the case, where the court recognized same-sex marriage. In this case, the court interpreted the law through the lens of equality and dignity, rather than adhering to traditional legal definitions. This reflects the views of modern natural law theorists, such as Ronald Dworkin, who argue that legal interpretation inherently involves moral judgment. You can't just have the law stand on its own and not connected with morality, which is where natural law comes in, right? And with regards to kinship, there is a connection, honestly, with kinship and natural law. The reason why I say this is because natural law can influence how kinship is judged. For example, when kinship is unfair, or the rule regarding kinship is unfair or discriminatory, courts may reject it using moral reasoning, which is where natural law comes in again.
But I also talked about how when judges are trying to decide a case, such as the case that you just made, it being interpreted differently, don't you think that causes an issue when it comes to the doctrine of the stare decisis, where law rely on previously decided judgments to try and interpret the new judgment or the new facts that they are being faced with? Don't you think it causes a problem?
Okay, it might cause a challenge, but I wouldn't say it's a problem, because cases are unique, cases are different. So when a certain court is relying on another or previous court's decision or stare decisis, they will have to look at the context of that case and also rely on the stare decisis. It wouldn't cause a problem because cases are unique, and they would have to apply morality or natural law. And because I did mention that legal positivism or natural law coexist with legal positivism, so it really, really wouldn't cause a problem because they coexist. Morality is not greedy. It opens up space. It welcomes legal positivism. So honestly, it wouldn't cause a problem.
It does coexist, but it does challenge legal positivism because authors such as Austin Hart are arguing on the other side of being like, cannot no longer be applied. As I talked about, or I had mentioned different authors, so I would like to first mention John Austin. So what does Austin say? So Austin talks about the existence of legal systems by a way of issuing commands. What is a command? A command is a way of trying to make people to. So as I had mentioned different theorists in regard to legal positivism. So the first theorist that I would like to talk about is John Austin. So John Austin explains the existence of legal systems in a way of issuing commands that are issued by a political superior. And if such commands are not being followed, they are backed up by a sanction. So what is a sanction? So a sanction essentially is a law. So when I was arguing, I talked about different theorists, and the first theorist I would like to talk about is John Austin. So who is John Austin? So John Austin explains, or the John Austin's theory, it explains the existence of legal system in a way of issuing sanctions by a political superior. So if the commands are not being followed, they are backed up by a sanction. And Austin states that sanctions will be instituted where a command is being disobeyed. Command, duty, and sanction, they are inseparable connected terms, which each embrace the same ideas as others. Moreover, a law is a command which obligates a person to do something. However, Kellens believes that law is normative. Why do I say this? So Kelsen states that law and morality, they rely on two logically separate sets of statements, and whereas law is an objective matter. So lastly, the theory of Herman Hart, who believes that law in terms of a hierarchy consists of primary and secondary rules. Hart states that a community consisting of primary rules only, it cannot have law. Why? Because in order for a society to have law, it must, in addition to primary rules, have secondary rules.
Natural law approaches in modern legal systems are further illustrated by key natural theorists. Thinkers such as Fuller, Dworkin, and Finis, they argue that law and morality are interconnected, whether it's through procedural fairness as Fuller would see it, or moral interpretation as Dworkin sees it, or basic human conduct as Finis sees it.
So to conclude my argument, I still highly believe that natural law legal system cannot be justified in modern legal societies, because as I had mentioned in the case of in a judicial setting where a judge has to decide whether a person has actually or must be convicted, it would be morally accepted that the person should not be convicted. In relation to law, which there's the Criminal Procedural Act, which regulates these processes, it's much more easy for the judges to actually take the decision of convicting a person based on the minimum of sentencing and all of that. Yeah.
Okay. To conclude my point and my debate, natural law definitely can still be justified in modern legal systems because they have evolved to accommodate the realities of contemporary law today. And while classical natural law approaches were rigid and morality driven, modern natural law now adopts a more nuanced position that complements legal positivism, as I had already mentioned that both these theories coexist according to natural law. Right. It also recognizes that law is grounded in social sources. As you had mentioned, that legal positivism is based on social facts, but it insists that its authority ultimately depends on its rational and normative force. And also, natural law aligns strongly with Ubuntu, which is a really critical position in our law today.
And that I'd really like to mention the case of S versus Mankwanyane, where the court took a shift or tried to draw a distinction as of the separation thesis. In this case, law overpowered and took an overpowering turn instead of morals. And